Hi there, my name is Sophia Rivera. I am a senior studying political science and professional writing, and today I'm going to be discussing restorative justice and its applications within the U.S. Federal Court of Claims. Imagine losing years of your life to wrongful imprisonment or having your ancestral land stripped away. What would justice look like for you? This is a question that the federal government has had to answer for quite some time. During the formative years of the government, and specifically the judiciary, they realized early on that they weren't equipped to handle the numerous claims brought on by private citizens against the federal government. So, in 1855, Congress established the U.S. Federal Court of Claims, or what's currently referred to as today. This court reviews the private claims and grievances that are brought on by private citizens against the government. The court reviews cases related to contract disputes, tax reimbursement, or work reimbursement, as well as other ongoing civil rights issues, including but not limited to indigenous tribes disputes or wrongful imprisonment. Restorative justice is at the heart of how the Federal Court of Claims operates. The Office of Justice Programs defines restorative justice as a process whereby parties with a stake in a specific offense resolve collectively how to deal with the aftermath of the offense and its implications for the future. This theory contrasts with our current criminal justice system and the focus of punishment rather than repairing the harm done by an individual who has that harm inflicted on them. Laura Bezalon, the former director of the Loyola Law School Project for the Innocent, talks about the shortcomings with our criminal justice system and how the restorative justice model contrasts.
Basic questions: what crime has been committed, who committed it, and what punishment is deserved? The restorative justice system asks, who was harmed, what are their needs, and whose obligation is it to meet those needs?
So, as she mentions, the restorative justice model looks at repairing harm done compared to our current criminal justice model that looks at punishing the offender and seeking restitution in that manner. So, as the Court of Claims currently stands, it is the court for restoration of unjust imprisonment, along with other ongoing problems that we see in our society. Another common type of case that is reviewed by the court is indigenous tribes' land removal disputes. Traditionally speaking, the indigenous tribes have experienced severe mistreatment from the government, from being forcibly removed from their land to having to assimilate to American culture without their consent. When the court began rendering judgments during the 19th century, many claims were brought on by indigenous tribes as a way of hoping to get justice for being removed from their land. In an effort to support these claims and help expedite the process, the Court of Claims enacted the Indian Claims Commission, an agency that was specifically focused on expediting the process of reviewing indigenous tribes' disputes. This is just another example of how the Court of Claims uses the restorative justice model in reviewing their cases and trying to restore justice to these specific parties. So while there are, of course, numerous claims being brought by the court, there are a lot of criticisms that arise with this court and its applications moving forward. Specifically, David Wilkins talks about these shortcomings in his book, Hollow Justice, specifically looking at the case system that I just mentioned. With indigenous tribes, oftentimes the court fails to properly render justice in the proper monetary compensation, or further, takes numerous decades to address these claims and often leaves parties without proper compensation. Senior judge on the court, Lauren Smith, also talks about these issues and the application of the court moving forward.
The next decade and into the 21st century is to both provide courts with the resources they need and also make sure we use them for the correct social problems, not those that they really can't solve.
As he demonstrates, it's important to recognize the limitations that the court has in being able to review the numerous cases that it receives the thousands of cases it receives every single year, and knowing how to best address these problems, especially with the application of the restorative justice model. And so ultimately, as we consider the future of the court, it's important to remember that monetary compensation can provide relief, but it cannot always replace the time that was taken from people's lives. And so, if we agree that the justice not always involves compensation, but also restoring harm, we as citizens must ask, what steps can be taken to ensure that the Federal Court of Claims embraces restorative justice principles to fully repair what has been lost? Thank you. You as well.